I was one of the speakers. It was basically for SMEs, where KEPSA was supporting SMEs for Rwanda, Kenya, and Uganda. I think Cameroon, basically, where business owners and basically SMEs, the work of KEPSA, which we definitely look at SMEs work more. And there were more insights, so I'll not want to go very deep. However, for those who don't understand what ADR is, basically, alternative dispute resolution is all those methods that are used to resolve disputes are outside court. So that the main examples I would say is arbitration, mediation. I'll not delve into the others. However, I will just seek to distinguish the difference between arbitration and mediation. Mediation is where parties go before a third party to help them resolve the dispute, but then the third party does not make a ruling or a judgment. So it's the parties, basically what we say, kuongea mnaelewana. Then you get into that agreement, and then that agreement is what now the parties adhere to. And however, in arbitration, the third party makes a decision just as a judge or a magistrate in a court would. So then now parties, of course, choose the arbitrator. However, the arbitrator's decision is binding. A mediator's decision is not any decision, because a mediator does not make a decision. It is the parties in the dispute who agree, and then the mediator just facilitates conversation. Having said that, having worked with SMEs and understanding very many things, and especially now post-COVID-19 recovery, and of course there being talks of a recession, and in Kenya this being an election year, and as you've seen also the prices of livelihood have gone up, you find that businesses disputes have arisen because of the COVID-19 and lack of fulfillment of some obligations between parties in a contract. The business case for alternative dispute resolution is this. Alternative dispute resolution is flexible because you can choose the choice of which dispute resolution, whether you want arbitration or mediation. Also, the costs are cheaper because you don't have to be represented by an advocate. You can represent yourself. Basically, you appear in your own right. As in law, we say you can appear pro se. And more importantly, the costs are lower because you don't have sometimes to pay a judge, it's not a judge, a lawyer, filing fees. So, and also flexibility is also in terms of venue. You can hold it, like right now, if parties agree, they can hold it here at this house I'm in or anywhere else. But more importantly is, why is a business case for ADR? By the time someone starts a business, either it's a small or medium enterprise, very many people, they don't really think, because by the time you're getting into a business agreement with someone, most of the time you find that you're not really thinking about a dispute. That is why we find that what you call the dispute resolution clause, people refer to it as a midnight clause. You just throw it in there so that the contract is fulfilled. So you find people negotiating every other clause when they're getting into either a lease agreement or a contract for supply of goods or services. But they forget to really think about what they would do in case of a dispute. Because of course, by the time you're getting into a contract with someone, no one really contemplates that this is one person who will be a potential foe or enemy in future. Now, the business case is this: disputes are definitely going to arise. And sometimes disputes are not because of a deliberate breach of contract. It's things like when, those of us who are KEPSA members, which I assume is most, I'm also a KEPSA member, and you've heard I do gender, the vice chair of gender. Many businesses actually folded. And more importantly, they were not able to give their obligation regarding employment and also contracts in terms of supply of goods and services. So disputes arose. Now, when you think about a dispute, by the time you're starting a business or by the time you're getting into a contract with someone for profit, your main or your core business is not dispute resolution. You're not a law firm, you're not the judiciary, you're not in the business of dispute resolution. So you cannot also want to be so sucked in the business of dispute resolution, such that even the core business which you started is somehow sidelined, or you find you're spending so many hours and so much money and resources trying to resolve a dispute by paying lawyers, going to court, doing witness, doing statements, all that work, which is really not the core business that you set out to do. Now, having said that, the main disputes that happen in SMEs are usually around supply of goods and services, contracts around that, contracts around breach of contract between lessors and lessees, basically breach of contracts for the core business, and employment matters. Construction and those who do construction work, of course, there's that aspect as well. Those who are involved, even if you're a small project contractor for, I'll say, since I know NCA levels, NCA 7, 8, the small contracts, either way. Now, when you deviate from whatever was your core business, you're wasting your time and you're spending your money. The business case for ADR is this. When you think about drafting your employment contracts, before you think of rushing to the employment court, of which now you know that the court has mandatory court annexed mediation for matters that they feel can be solved through mediation, consider having mediation clauses in your contracts. Many companies have actually approached me, and you inculcate that as a clause, so that before once a dispute arises, instead of running to courts or whatever, you have either an internal workplace mediation strategy, or further, you have a mediator that's mediation clause rather, where you can approach a set list of mediators, and Lawrence, of course, being of NCIA and others, many arbitral institutions and organizations empanel mediators so that you have mediation. The beauty about mediation is you can have it in your company such that you don't have to be the one, basically the mediator is not paid by the parties. You can have it that you have a mediator who's a panel, and then when you meet the mediator, they have a flat fee. You can have a flat fee. Ordinarily, mediators and arbitrators are paid hourly, but that's something to think about, especially for your employment matters, and also thinking about your contracts. When drafting your contracts and the lawyer gives you your contracts for signing between you and the other party, think about having a mediation clause. I'm shying away a bit from arbitration because I'm specifically addressing small and medium enterprises, and understanding that arbitration of the two, arbitration is more costly and might take slightly longer time. In my career in mediation, I think I've handled now close to 80 mediations, and I can tell you mediations ordinarily don't take more than 2 days to resolve. Sometimes you find it's just the small issues, like perhaps one person did not tell them that they can't pay the installment on time, or they did not deliver the goods on time and did not inform them. So sometimes you find even just a simple apology or just shaking hands suffices, because the thing with mediation, it also maintains a relationship. Because by the time you're getting into a contract with a person, even if it's a marriage contract, for instance, you have a relationship. Even a business relationship is a relationship. So moving forward, what I would encourage, because I want to speak really fast, at the basic level, start understanding basic mediation, and also inculcate mediation clauses in your contract, be it employment contracts, supply of goods contracts, lessee contracts, and more the bigger SMEs perhaps that have a high turnover in terms of or handling larger staff. Consider also having a mediation sort of panel, and also sensitization is key for those who have employees, for those who have companies everywhere and branches. I will stop there. I'm open to questions. I'll put my email address in case anyone is interested in asking questions after this webinar about such things. And I thank you again for the opportunity. Thank you, and back to you, Kananu.
Fantastic. Mercy, thank you for those very great insights that give a clear overview on the benefits and use of alternative dispute resolution mechanisms. Now, Alim, over to you so that we can then discuss the advantages of arbitration in enforcement contrasted with litigation.
Thank you very much, Kananu. Thank you, Mercy. I want to start off by talking a little bit about what arbitration is. Many of you may not be familiar with the process of arbitration. I then want to talk a little bit about the advantages of arbitration. And in doing so, I want to focus on enforcement, or the relative ease of enforcement of arbitral awards and the finality of those awards, and how that is advantageous to your business, given that most contracts today are transnational, given that today we live in a globalized world and we have to do business with companies that are in different member states of our own, and how in arbitration, that is much more advantageous to you as a company as compared to litigation. So what is arbitration? First of all, the definition is it is a device whereby the settlement of a particular question which is of interest to two or more persons is entrusted to either one or more persons, who can be the arbitrator or the arbitral tribunal, who derive their powers from a private agreement, not from the authorities of the state, and who proceed to decide the case on the basis of that agreement. And this is important, and that definition is very loaded, because there are several elements in there that I want to bring to your attention straight away. Those elements are that there is an agreement to arbitrate. Arbitration is voluntary, first and foremost. Second, there is a choice of the arbitrator, which means you as the parties to your commercial agreement can pick an arbitrator who you believe has the relevant expertise specific to the contract that you're entering into. So you can choose someone who has a niche in that area and who has a good record. Another element is that this decision of the tribunal will be binding, will be final, and will be capable of enforcement. And that's really the area I'm going to focus on today. But two more central elements I still want to point out is that this is a private mechanism controlled by the parties and an alternative to the state. What that means is that you as the parties can decide on the rules applicable to the arbitration. You can decide on the law applicable to the arbitration. You can even decide on the kind of powers that you want to give the arbitrator or powers that you may want to take away from the arbitrator. Essentially, it means that you as the parties control the process, you control the venue, you control how long the arbitration takes, you even control exactly where you meet and when you meet, so it can be convenient for you. So there are many advantages here compared to litigation from the outset, because it means you can have this arbitration in a way that is comfortable for the parties and in a way that suits your schedule and is confidential, confidentiality being very important. So that's the case for arbitration, essentially, that we're putting forward. But let's talk a little bit about enforcement. And to me, this is the real important or the most advantageous area. In litigation, in the event you have a dispute, you have to choose which court to go to resolve that dispute. Sometimes this will be set out in the contract. What then happens is, at the end of it, you have a judgment. You then have the difficulty of enforcing that particular judgment. Now, in arbitration, there is something called the New York Convention, which is a treaty. And there are almost 169 states that are now contracting parties to the New York Convention. The New York Convention is a pro-enforcement regime. That means that every contracting state who is a state party to the New York Convention may take their award and enforce it in any other member state. And the basis of the New York Convention is that an award made in one state may be enforced in another contracting state on the same conditions that are set out in the New York Convention and on conditions that are no more burdensome than the enforcement and recognition of domestic awards, which means your international award will be treated as a domestic award in any other contracting state insofar as recognition and enforcement of that award is concerned. What does that mean for you? It means that you can forum shop. You can look for the best state or the most convenient state to enforce your award. It means you can look for the assets. You can find the assets. And once you know exactly where the other party has assets, you can seek enforcement in that state. You can also seek enforcement in multiple states, not just one. So you can go to every state that has an asset and seek enforcement of the same award in each of those states. How is that highly advantageous compared to litigation? If you were to seek to enforce a judgment in a country, you would need something called a Reciprocal Enforcement Act, by and large. And in Kenya, there is a Reciprocal Enforcement Act, and it provides a schedule of the countries where you can seek recognition and enforcement of a judgment. How many states are listed in that schedule? 8 in total. Those 8 are a start. They do include the UK and Australia, and that might be good for many people, but they don't have 169 member states. The New York Convention means that if you pursue arbitration as opposed to litigation, once you have a binding award, you can look to 169 countries to enforce that award. And you can do so on conditions that are no more burdensome than a domestic award. So that is the primary advantage that I want to bring to your attention today when we talk about arbitration vis-a-vis litigation and enforcement. If there's any takeaway, and I'm keeping today's session as short as possible because we only have 8 minutes, it's that there is a pro-enforcement regime called the New York Convention, which applies to final awards and which applies to all member states. And this particular pro-enforcement regime provides minimal conditions for enforcement. Now, there are some conditions, or there are some situations where recognition and enforcement of an award may be refused. And those are set out in the New York Convention. And just to give you an idea, those particular factors for refusal for recognition and enforcement almost mimic the Section 35 of our Kenyan Arbitration Act, which provide the grounds upon which you may set aside an arbitral award. As many of you may know, or the lawyers here may know, those grounds are very limited and they are highly circumscribed. We also know, or many of us may not know, that there is no appeal on the merits of an arbitral award. What that means is that arbitration awards are binding, they are final. You cannot appeal them. You can, however, make an application to set aside an award. And that application comes under the Section 35 I've just talked about, which provides very, very minimal grounds upon which you can actually set aside an award. Those are the same grounds that are set out in the New York Convention for refusal to recognize and enforce an award. In short, what we are saying is that the advantage to you of arbitration over litigation is the opportunity to look to different jurisdictions for enforcement and a multitude of jurisdictions. I will stop there because the time is short and hand over to my colleagues. If there are any questions at the end on recognition and enforcement, I'll be happy to come back to them. Thank you.
Thank you so much, Alim. Again, many questions are beginning to come up. Shafiq, Emma, I see the questions that you're posting, and we're definitely going to address those as we close the proceedings during the Q&A. Samata Abdi, we've also seen your question, and that is taken note of. For the rest of you, please keep posting your questions in the chat box. These are being taken note of, and we shall aggregate them and post them to the speakers at the end. For now, I'd like to invite Lawrence Ngugi, the CEO of the Nairobi Center for International Arbitration, to speak on cost-effective organization for case administration. Lawrence, over to you.
Thank you, Kananu. Let me first appreciate those who have joined us today. It was our desire as NCIA, ICC and KEPSA to enter into this quite important subject concerning business, the subject of dispute. My colleagues have alluded to the fact that at the time when parties agree to enter into any transaction, normally they assume that there will be no challenges. But the reality is that once in a while transactions will have disputes. And in the course of designing their transaction, they enter into agreements. Those agreements provide for a means by which those disputes can be resolved, either by mediation or arbitration, to which my colleagues have alluded to. Now, I know, of course, at the top of your mind as business is a question of cost. How much will it cost you to be involved in any one of these processes? And of course, the assumption here is that no company, apart from NCIA and others, is in the business of dispute resolution. Your business is set up to provide a particular service for which it gains a return on revenue. And so it is a desire of every company to avoid dispute resolution or litigation unless it is really necessary. And when it becomes necessary, the subject of how much it costs is still top of the mind of any business. And so I will speak to the question of cost right from the moment you enter into this transaction, and especially when a dispute does in the end arise. You'd want to know what is the nature of costs involved, how can you determine them, is there a possibility that you can mitigate about those costs, and the like. So coming to one, the element of costs. And I'll take a typical case of an arbitration. We normally divide them into two. So one, the arbitration cost, or the cost of the arbitration, and the second being the costs incurred by parties, for instance, legal fees and such like fees. So in terms of arbitration cost, here the costs that are involved is the fees of the tribunal, that is the arbitrators, to hear and determine the matter, the reasonable travel and other expenses incurred by the arbitrator or arbitrators if there are many, the reasonable costs of expert advice and other assistance that may be required by the tribunal. So for instance, if it is a construction dispute or a complex dispute which involves some technical skill, the arbitrators may require expert advice on particular aspects of the arbitration. Such cost would then, of course, be met as arbitration costs. Then there's the other costs, for instance, fees and expenses of an appointing authority. So where the parties have agreed that should a dispute arise, for instance, the Nairobi Center for International Arbitration will be involved in the process of appointing the arbitrator or arbitrators. That is, again, a fee and expense which is met under the cost of the arbitration. Then the second category, which I've mentioned, is the legal and other costs incurred by the parties. Of course, these have to be reasonable. Parties may retain advocates. They may retain such other required expertise that they bring into the preparation for the arbitration, and in the course of the arbitration, there may be witnesses that are required, their travel and expenses, with the rider, of course, that these costs should be reasonable, but they will ultimately feed into the ultimate costs of the arbitration. Mediation may be slightly different. Maybe all these parties may not be required, but if they are in the course of the mediation involved, parties in the course of negotiation may also come up with a way in which they deal not only with the substance of the question before mediation, but also the costs that are associated with it. But I'll take the typical case of an arbitration. Now, given those are the elements of the costs, the cost of the arbitration and costs which are incurred by the parties and are recoverable, what is the criteria for allocating these costs? Ordinarily, or in most cases, costs are paid by the unsuccessful party or parties. So the arbitrator will hear both parties or multiple parties in case there are many. They will arrive at a determination, and based on the level of success of one or the other party, arbitrators will very often give an order for costs where the party who was unsuccessful will bear those costs, except where in exceptional circumstances, costs may be given outside of that general principle, in which case maybe it may be assessed the relative success of each party in the arbitration, or indeed based on the conduct of the parties, costs may be allocated differently. And so once the costs are ascertained, then the party who bears the cost for the proceedings will be expected to pay the costs. In terms of when the parties will get to know exactly what costs are allocated, given that power is assigned to the tribunal may decide to include the amount of costs within the final award, or it may have been determined right from the beginning that the issue of costs will be reserved to be determined at the end, and therefore there will be a final award on the issues in dispute, and then a subsequent separate decision will be given by the tribunal with regards to cost. Now, sometimes there's an invitation to the parties to make submissions with regards to the question of cost itself, and then the tribunal makes an informed decision thereafter. Many aspects will be taken into account when the question of cost is being determined. For instance, the complexity of the case. It might also involve the people involved in the dispute, the arbitrators. Where are they from? My colleague Visram has mentioned it could be an international dispute. The economic climate of the places where the arbitrators come from, and therefore the cost of living. If you have retained counsel, and this is a cross-border dispute, where are these advocates from? what is the cost of living in their respective jurisdictions. All these things might eventually feed into the question of costs. Now, given the degree of diversity on this question, as a business, you want to be concerned right from the moment when you're negotiating the agreement, what will be the eventual impact should a dispute arise? Is it a dispute that is going to be heard and determined by one arbitrator? Is it a dispute that is going to be heard and determined by multiple, 3 arbitrators, for instance, because that will have an impact on the cost? What will be the level of involvement of in-house counsel? What will be the involvement of external counsel? So if you have your own legal department, if you're a large company, what degree of involvement will your own counsel within be involved in the process of preparing for the case? If you have to engage external counsel outside of yourself, what will be the cost that will come with engaging those counsel? What level of control and involvement of your in-house counsel will there be with the external counsel? When the choice of what process, is it going to be a document-only arbitration or the like, and such issues will inform the question of cost, which again, we can interact later, seeing as time has already been spent. Thank you, Kananu.
Thank you so much. Thank you so much, Lawrence. I think you've touched on the heart of things. Money matters, and I can see questions are being posed about what is causing the escalation of this cost, and we shall address that in our Q&A session. For now, Dr. Mwigwa, we're handing over to you to address how we can actually nurture international commercial arbitration in Africa and its use. Over to you, Doctor.
Thank you very much. I've listened to my colleagues and they have covered much of the groundwork, what needs to be done. I'm supposed to talk about how to nurture or how to foster international commercial arbitration in Africa. But that is a leap that is too far. We may need to start with what Mercy Okiru said about conflict management mechanisms. For you to talk about ADR, you need to understand what it is, so that you don't talk about arbitration when you mean mediation. Mercy Okiru took us through the various concepts, and it is important, even if you take away nothing else from this, to know that ADR is a whole spectrum. And it starts with Article 33 of the UN Charter, which is to the effect that if there's a dispute anywhere in the world, it shall be dealt with through negotiation, conciliation, adjudication, and arbitration and diplomatic methods. We move away now from the New York, from that to the New York Convention, which was ably presented by Alim Visram. So I'll not repeat myself. So if you want to know something about international commercial arbitration, you go back to the New York Convention. And the New York Convention is very short, and all of you have it. You have it on your phone in PDF. It's to the effect that countries got together and decided that we are going to be pro-arbitration. And whenever there is an arbitration clause, we shall stay proceedings in court and go for arbitration. This is reflected in Section 6 of our Arbitration Act. And then the countries agreed, we shall come back and there shall be an award. And this award shall be enforceable across the 160-something countries. Okay, that is very key, and that is important to remember. And I'll come back to it in a minute. It's also important to remember that ADR mechanisms are not all the same. There are those that are coercive, very, very coercive. You're forced to do something. Win, lose, arbitration is one of them. There are those that are non-coercive. You have negotiation and mediation. The party autonomy is there, and what you do at the end of it is what the parties have agreed. So arbitration is a coercive mechanism. It's like a judgment of the court. It's not a win-win. It is not cheap at all. Let no one tell you that. It's quite expensive. But again, the question of expensive or cheap is a matter we can discuss later. So in regard to international commercial arbitration in Africa, why should we foster it at all? Africa is a huge continent with different legal systems, different languages, but legal systems are different. The selling point for arbitration is that arbitration can be applied across the borders. It's a bridge across legal systems. That's the only selling point. That is a bridge across jurisdictions. And Visram already told you that if you have an award, you can enforce it across very many jurisdictions. Of course, there's a debate now coming up about the Judgment Convention 2019. Check it out. So that the 4 countries he was talking about will be 160. If you have a judgment, then you can enforce it across 160 countries. So that will change the landscape, but we are not yet there. Therefore, if you are trading in Africa and you need to go to an arbitration, it's a bridge across jurisdictions. If you are trading with DRC, Congo, or any other country, you'll be able to go there. I saw a question on the chat about whether you can be represented or who should represent you in an arbitration. This is one area where you don't need to be a lawyer to be a representative or to practice in the 160 countries. You can go there and present your case. And that's one selling point for all of us. But why is it that arbitration isn't picking up as fast as it should across Africa? And there are very many factors hindering the growth of international commercial arbitration. I'll just list them down. There's bias against Africa. Everybody thinks Africa is where bad things happen. Sometimes we don't have the capacity, institutional or personal. We don't market properly or adequately. And there's a perception of corruption and government interference in Africa. And international traders do not want that kind of interference by national courts. And there's a tendency across the board to appoint arbitrators from other jurisdictions away from Africa. Africa is the least represented. We also have very many badly drafted arbitration clauses across Africa. I was discussing a clause that said the language should be Chinese, but it was very specific, Mandarin, and the place of arbitration shall be Shanghai, China. And now the lawyer from here received documents in Mandarin. So that's different. And then Africa is not one combined continent. It is, there are very many different cultures, and conflict management is culture specific. How do we then harmonize the various cultures? What do I suggest by way of way forward? We need to start aggressively marketing Africa as a venue, as a seat of arbitration, the way Mauritius markets their beaches. We can market our parks. We can market our many beautiful buildings. We should begin to tell people that we have 5G connectivity in Nairobi, because when you talk about Africa, they imagine an acacia tree and somebody who is grazing cows and they can dance. That we need to move away from that. We need to build capacity by education and training. And we need to address those governance challenges like corruption. The question of minimum court interference, and that's a debate that is live now, it needs to be addressed. And these African arbitrators, they need to come up, stand up, and go out there and be counted, and they need to show their qualifications. And we need also for in-house lawyers to begin to draft those conflict management clauses carefully so that we don't come up with what is called toxic clauses. At the national level, there should be a continuing debate about how to align national laws with international best practices. So is it possible? Yes, it's an ideal that can be achieved. It is achievable, but it is yet to be realized. Africa has huge potential as a preferred venue for international commercial arbitration, but we need to do that. There's a lot of work to be done. Thank you very much.
Thank you so much, Dr. Muiwa, for giving us that very good perspective. Attendees, we have come to the end of the formal presentations by our speakers, and I shall now just request all of them to please turn their cameras on so that we can go into a question and answer session, which I shall be guiding based on what I have seen posted in the chats. Maybe we can start with you, Mercy, because a question came in as you were speaking about the benefits of mediation to businesses. And the concern here seems to be how SMEs can reap full benefits of the process of ADR, but the specific question here pertains to mediation and arbitration to realize the full benefits. Mercy, maybe you can speak to that.
Okay, thank you, Kananu, and thank you. I read the question in the chat and I felt like it would come my way, so I manifested the question. Nonetheless, I'd say this just quickly. The disadvantages of mediation, as if I was to say, is perhaps where there's a stark power imbalance, where perhaps someone is coming with a team of 17 lawyers and you are just self-representing. But nonetheless, another issue that can be said to be, has been said before to be a disadvantage of mediation is enforceability, where people feel that it's not like a court order that you can now go and enforce and auction someone's property. And also the fact that it's voluntary, even in terms of attending. Some parties feel that since there's an option of a party leaving at any time, someone can just up and leave. However, I will tell you the remedies because you asked a practical example. When choosing your mediator, always choose an experienced mediator or have an organization that empanels experienced mediators to pick. The crux of this is this. When you look at the Nairobi Center for International Arbitration, it basically has mediators who are, I'd say, classified according to their areas of interest and also their experience. My apologies for that. Also, no one stops you, nothing stops you from enforcing a mediation agreement if it emanates from two ways. If the two of you just go and understand each other on the side and come up with an agreement, the Civil Procedure Act allows you to go to court with that mediation agreement and have it adopted by the court as though it emanated from the court. That is the Civil Procedure Act of Kenya. If me and you have a dispute in KEPSA or whatever, then we come up with a agreement. You can take it to court and the court will adopt it as its own order. So you can enforce it, that auction they usually do for other court orders. The other thing is, if you have a case in court right now, and you want to use this mediation, you don't have to wait to be referred to court and next mediation. Just go directly to the Milimani law courts or any high court in this country, actually, even a magistrate's court nowadays. Just go and say, I want to go to court and next mediation. At that point, a mediator will be assigned to you and you don't have to pay them. And the outcome will be that the court will adopt it as a order of its own. So experienced mediator, just ensure, even if you don't know Lawrence Ngugi of NCIA, go to the court registrar, court and next mediation registrar, it's online. Suited and their contacts and emails are there. Just look for one because an experienced mediator will be able to see how to move the mediation forward, because sometimes parties come hot, parties come angry, parties come everything, but at the end of the day an experienced mediator will know how to facilitate the mediation to move forward as opposed to looking behind. As to arbitration, the disadvantages are costs and time. I'll say this, costs and times are together, they're in one WhatsApp group, because the longer an arbitration takes, the longer you have to pay the number of hours to an arbitrator, the longer you have to pay a lawyer if you're represented. Now, the problem comes with when sometimes the parties or the client, as it were, does not really focus on knowing what you just instruct your lawyer and go. Start understanding that nowadays, for instance, the Chartered Institute of Arbitrators 2020 rules, I will type the name there. If you Google, you'll find them. You realize you can ask for an emergency arbitration, which open and shut within 60 days, you have your final award. If you want an emergency arbitration, that is possible. The Nairobi Center for International Arbitration can also do that. So don't also be that ignorant client or that party. All this information is there. Now, how can we address these disadvantages? One, when drafting contracts, do not be the person who relies on your lawyer to give you the contract. Sometimes look for a third and second opinion. Ensure that what we are saying, the dispute resolution clause, the way people put it as a midnight clause, please ensure that you think about it and think about how you can market it. How you can capture it well. Awareness and understanding. Nowadays, so many people in this town who are trained to do mediation. In fact, the Quarter-Next mediation program, only like maybe 50% nowadays are lawyers. So consider that. Awareness, understanding. Walk to your nearest court, high court, judiciary, magistrate. Find out how Quarter-Next mediation works. Also consider when you appoint a mediator or an arbitrator, consider having the cost capped. You say for this whole mediation, we are paying you 20,000, all of it, instead of paying hourly. That's another thing. As for the different dynamic duo, as to a foreign contractor or a foreign person with more power, that is why we said when drafting the contract, you must be sure you can put mediation 20 days. After 20 days, if it does not work, go to arbitration. But I can discuss this further. I know. Thank you.
Yeah. All right, thank you so much, Mercy. I see you are going to preempt something there, but allow me, please, on the basis of that, to segue back to Dr. Mwigwa on a question that was posed, Dr. Mwigwa, about the potential imbalance that exists when you have parties contracting, with one being a foreigner and another a local. The import of that question that was raised is the financial power dynamic that emanates, and if this impacts the dispute resolution clauses. Maybe you can speak a little bit to that, Dr. Mwigwa?
Yes, people who teach arbitration or preach it will tell you that there is party autonomy, but is there party autonomy? Most of the contracts you get into, including with multinationals, are contained in a standard form agreement. So certainly there is power imbalance. You should be very careful before you get into international commercial arbitration. It is not cheap, it can cripple you. The institutions that exist have schedules, and those schedules can horrify you. They can cripple you. Look at them very carefully, because they tell you this is a cost. And there are many, many other hidden costs. So you heard about 3 arbitrators, their institutional costs, and so on. Yes, there is power imbalance. And yes, it's an ongoing debate about whether then party autonomy does exist at all. Arbitration is not perfect, but it has that selling point that I told you about. You can exercise it across 160 or more jurisdictions. Thank you.
Great, thank you. Thank you for that, Dr. Mwigwa. Alim, let me bring you into the conversation now. As you know, you engage with and you also train lawyers. There's been quite a bit of concern about the dominance of lawyers in the ADR space. That's the whole range of it, the mediation and arbitration spectrum. Would you consider that there is complete necessity to have lawyers in the process? What are your views on it?
Thank you, Kanani. I think that's a good question, and I understand that this is a concern for the non-lawyers. The simple answer is no. An arbitrator may come from any background. He or she need not be a lawyer. They could be a professional from any background. And increasingly, we are seeing today in Kenya, we have many arbitrators who come from the ranks of quantity surveyors, who are architects, and especially when dealing with construction-related disputes, or disputes that are not typically legal in nature, or do not pose contractual questions where you need to sort of interpret a legal scenario or interpret a contract and come to a legal finding, but rather you need to understand the numbers, you need to understand the scenario, you need to have experience in that area. So arbitrators should be selected by the parties based on the specific dispute that they have, and they should pick someone who is an expert in that area. Those may not always be lawyers, and increasingly are not lawyers. I think the second point to make in terms of that is that the Chartered Institute of Arbitrators has many, many fellows who are not actually lawyers. There are architects, there are QSs, there are even chartered arbitrators in the Chartered Institute of Arbitrators who do not come from the ranks of lawyers. So despite the perception that all arbitrators are lawyers, it's not necessarily the case. And I think we are encouraging non-lawyers to come forward. If you don't mind, Kananu, I'd like to just comment on a question that was raised earlier to Mercy And just add a small caveat. When Mercy was talking about mediation, I just wanted to bring to the attention of our participants something called the United Nations Convention on International Settlements Agreements relating for mediation, which is also known as the Singapore Convention. So there is now a Singapore Convention which is specific to mediation, and it regulates the enforceability of settlement agreements that resolve commercial disputes arising through mediation. And what that means is that you can enforce your mediation agreement in any other contracting state to the Singapore Convention, allowing mediation to be enforced similarly to awards and arbitration across multiple jurisdictions. And that Singapore Convention is making headway right now and is an important aspect to consider when we talk about international enforceability of both mediation agreements and arbitration agreements, or rather arbitration awards.
Thank you so much, Alim. I think you make very good points about the internationality of mediation as well. On the point you've raised about the lawyer, non-lawyer participation in the process, I think the criticism that's coming through, Lawrence, and I want to invite you here to comment on the role of non-lawyers within the ADR processes. There's a perception that so far there's been quite a bit of training given in the market to equip people to be dispute resolvers. And the question is, these dispute resolvers, are they responding to market? Is there a market that understands these mechanisms? Lawrence, maybe you can speak a little bit to that.
Thank you, Kananu. Contrary to wide belief, the very practice of arbitration, at least in Kenya as a jurisdiction, was initially commenced by people who were involved mainly in quantity surveying, architecture, engineering, civil engineers, and the like. And it is only in the mid-90s, towards the year 2000, when lawyers also started taking up arbitration seriously as a practice. Now, of course, given that lawyers are trained primarily to resolve disputes or to be involved in the process of dispute resolution, as the years have gone by, more and more lawyers have acquired the skill, or at least qualification, in arbitration. However, even though that is the case, that is not to say that other professionals are not involved in the process of arbitration. So you will find institutions like the Institute of Engineers, quantity surveyors, architects, still maintain a panel of their own membership that are involved heavily in arbitration and, for instance, adjudication, especially in the construction sector. When I look at NCI, for instance, we do maintain a panel of mediators and arbitrators, both international and domestic. And in this panel are people whose primary qualification or field is as wide as engineering, architecture, quantity survey, and of course, lawyers are not left behind. So when looked in totality, we began with non-lawyers. Lawyers have been onboarded, I think, quite naturally, but it has not dispensed with the need to have these other professionals involved in the arbitration and adjudication space. As we go out to train, as we go out to market this as a professional practice, we do not discriminate against non-lawyer professions. We are engaging with these bodies which are involved in other professions to offer training to their professionals. And by that, we do hope we can generate sufficient interest in other professions so that they can be part and parcel of the dispute resolution processes other than litigation. For the lawyers, specific training so that we also do not see the litigation mindset creeping into dispute resolution. So retraining lawyers to think dispute resolution outside of the adversarial mode. So I would say for those who are involved in this space, we are making every effort to meet to the specific demands of the market, so that you as the business, when you come to ask, propose for me a professional in this or that mediation or arbitration, we will assess the kind of dispute and what is required, and in making a proposal or appointing an individual, it will meet the specific needs of the dispute. No dispute is exactly the same as the other, and so therefore, as we have this mix cafeteria, we are able then to select people depending on the complexity, nature, or industry involved in any one dispute. Of course, there's call for more interaction between the user, the entities, and the practitioners, so that then we can continue to tailor our professionals based on the needs that are coming.
Thank you so much, Lawrence, for that very comprehensive bit of information that gives a robust view. Dr. Mwigwa, let me bring you in because you've been a bit quiet. We have the issue that's been raised about the statutory limitation and running of the ADR processes. May I please ask you in a very succinct fashion to give a comment on this, to then allow me to have each speaker give their takeaway, a very quick takeaway for that you want our audience to bear in mind.
Question, Chair, because I wasn't able to read it.
Oh no, it's a question that I've summarized. Statute of limitations and ADR. Do parties compromise their rights by engaging in ADR and risk, being locked out of the litigations forum?
Very well. We began by talking about the New York Convention, and you are referring to a contract. There has to be a contract. A contract is offer, acceptance, consideration, and there are time limitations within which you can bring a matter in contract. I think in Kenya it's about 6 years. So one of the objections that usually arises is that the matter cannot be heard by an arbitrator because it is time barred. So as you negotiate, as you get into ADR, know that your time is running, at least in the Kenyan jurisdiction, and it will be raised. And they will be saying there cannot be a contract that can be litigated on because of time limitations. There is no exception. Just remember this, your time will be running, it will be raised, and it can be ruled against you. And the arbitral tribunal has a special power called competence. It can rule on your contract and decide it's null and void, even when it is sitting on that null and void, section 17 of our act. So time limitation is something you have to be very careful about. A lot of people go to mediation in bad faith just to see what you have. And they drag you along until a few days after expiry. So my view is keep your time on the clock and see what you can do.
Okay, thank you so much. Attendees, let me say this, we shall shortly have Mwaniki sharing all the contacts of the panelists, and this will allow you to ask any questions that you may feel I have not adequately posed during the session that we've had, so that you can engage with them. I know we are now at 1 o'clock on the dot, and I will therefore please request our speakers, Mercy, I'll start with you in the order that we did our presentations, to simply give your 30-minute takeaway. What do you tell the audience they need to know or bear in mind as they're winding this down? Mercy, briefly, please. Mercy, microphone. My apologies. I'm saying, I know I can be long-winded because I'm just passionate about this subject, so I'll quickly put this in 2 ways. One is awareness. Don't be that person. You're the one paying, you're the owner of the business. You need to know also if a dispute arises what you need to do. So don't be that person who does not know what's up. Another thing is awareness, even within staff. And as I said at the beginning, even just calling, I know Dr. Kariuki is expensive, but he does it pro bono sometimes when he always does that. Invite one of the professionals here to just come and talk to your office around dispute resolution so that you also understand ADR. 2 hours, you'll understand good things and it will help you. Last thing,
draft contracts that you understand what would happen if the dispute resolution clause happens. As Dr. Kariuki has said, you could just sign a contract and you find that the contract will be resolved, the dispute in Paris, and you are just here in Kenya trying to make money. So understand how you draft your contracts. Awareness is key, and don't be feeling bad to ask questions, and explore the resources at hand, like as I've posted in the chat, Quarternext Mediation. I'm grateful for this opportunity. KEPSA, thank you. Of course, ICC Kenya, I'm also on the arbitration committee, and NCIA. So I'm wearing 3 hats, but today I was wearing my KEPSA hat, and I'm pleased. And I wish to have this more, perhaps a more in-depth intensive training. Thank you so much, Kananu, and be blessed, everyone. Have a good afternoon.
Thank you so much, Mercy. Aline, your snippets of wisdom on this very robust topic.
Thank you very much, Kananu. I think the takeaway for everyone in the business sector is that ADR presents an opportunity to resolve your dispute in a timely, convenient manner, and to select an individual that you believe is truly an expert in the area that your dispute has arisen in. And I think one of the things that you might want to consider is that, as opposed to litigation, once you have an award, you have multiple opportunities in multiple forums for enforcement. You can look for the assets, and having located them, you can enforce that award in many different jurisdictions to recover. So my takeaway would be, consider ADR, take time to understand it and utilize it. We have a lot of opportunity to be trained in this area and to learn a lot in this area in Kenya. So please, I encourage you all to learn more about it and to consider it in your business. Thank you.
Fantastic. Lawrence?
Once again, let me thank everyone who has participated today. Since I was speaking to the question of costs, I would ask, please think about the alternative. If you have no control over how your dispute is managed, you have given up the option of managing a significant risk of your business, which is dispute. As that dispute resolution clause is drawn, please realize that it could mean the survival of your business. Arbitration, mediation, and other methods of ADR can be sustainable and cost efficient if those who are involved in the process, including the board that makes the decision to go into or not, is aware about these processes. So I invite you to look at our cost outlines. I invite you to engage with us so that we can tailor trainings that are specific to board, specific to legal counsel, specific to project managers, so that each person is aware, and then you can control the level of cost. At the end of the day, you want to sustain and maintain business relations even as disputes have been resolved. We hope to interact with you more on these issues.
Thank you so much, Lawrence and Dr. Mwigwa.
Thank you very much for listening to us. In this era of globalization, ADR is something that is here to stay. We have our own Article 159 that legalizes it in Kenya. We spoke about Article 33 of the UN Charter. Very importantly, Mercy did say something about my pro bono work. Anything I write is available to the public for free, including all these books behind me. So what I will do, Kananu, if you give me the email addresses of all these people, I will send them a book called Settling Disputes Through Arbitration in Kenya, a foundational book that will teach you everything we are talking about today for free. And that's my contribution. The second thing I want to say, especially to lawyers, we need to be very humble. This business of calling ourselves learned when we know nothing, it is very bad. If you go into construction adjudication, for example, you learn very many new things. Project management, project finance, we need to go back and learn and learn and learn. Finally, in international arbitration, everybody, every professional is welcome. It's a profession in itself, and everyone is welcome. Thank you very much.
Thank you so much, Dr. Mwigwa. On my part, dear attendees, I will say to you that ADR gives you options and it gives you control over the navigation of your disputes. As you've heard, on account of this participation, you will get freebie, but highly beneficial information that will be in the form of that book from Dr. Mwigwa. I had said earlier that the email addresses would be shared for those presenting, but I'm informed that the organizers will share everyone who's with everybody who's participated an email and also perhaps a recording of this session. You shall therefore also be provided then the proper email addresses and the contacts that the speakers wish to designate for communication originating from this forum. I thank you very much for your attention and also for your indulgence in extending this session just a little bit. So thank you, and may all of you have a very good afternoon. Thank you.
Thank you. Bye, everyone.